Hello again, Hilary Garcia with Disability Rights Texas. I'm a healthcare attorney, and this is session 3 on appeal hearings of our 3-part session of Medicaid denials and appeals. So this is our focus on what you should do after or when making a determination of should you proceed to a Medicaid fair hearing. So you've been through the initial appeal phase, you requested an appeal, you've gotten a file denial notice. Now you know that you're at the stage to request a fair hearing. So there may be some trepidation or maybe some like, I don't know if I should do this. Should I appeal further? I've already kind of lost on the secondary appeal. Almost always your answer is going to be yes, you should request an appeal. One, because you're going to want to ask for continued services. 2, you can always withdraw a request for a fair hearing if you feel like the documentation isn't there, or if you feel like, well, maybe the decision was correct, which often than not, you're not going to have that circumstance, but you have the right to withdraw rather than proceed to a fair hearing. Again, because we stress so much continuation of services, we don't see that there's a detraction to you asking for a fair hearing and later on deciding that you don't want to proceed. But because you have a short window to make a decision for continued services, we always say yes. Although technically you have 120 days, that's a long time to request a Medicaid fair hearing. 10 days is a shorter window. We always say yes, go ahead and request it. And you, during the pendency time of them deciding or putting forth your actual fair hearing date, then you can, that gives you just more time to do all these other things that we've listed. But we did want to note that, if you can't get letters, if your medical professionals aren't going to be supportive, there's still time for you to make a decision on, okay, now I have more information that I didn't have unless I requested a fair hearing. Because until you request a fair hearing, you don't necessarily get all the information from the managed care company on what documentation, what policy. You might get it named or listed in your denial notice, but don't physically send it to you until you request your fair hearing. So unless you kind of do a Google search on your own, or request it formally from the MCO, you might end up seeing the policy, you might end up seeing the rules, you might end up seeing copies of your assessment. There's a lot of information you might be missing at this stage when you're determining, should I do this? But that's information that you will get as soon as the answer is yes, I'm going to request this Medicaid fair hearing. You will get the evidence packet. And then, of course, you can also request your case file at that point too. And if you hadn't received it yet, you should definitely receive it before your fair hearing. So again, you'll get a plethora of information that you can talk to medical professionals about, so the beneficiary specialist, to see and get a better gauge of, okay, I've requested the fair hearing, made sure, continued services are already in place, so I don't have to worry about losing anything. Now that I've done that, now that I have more information, let's see, should we continue? Should we continue the fight, or will we withdraw? And again, it's just guaranteeing at least that you have, that you're not giving away an option for the beneficiary to appeal, because they have the right to continue the process. Their representatives have the right to continue the fight on their behalf through a Medicaid fair hearing. Again, because of the short window, we'd recommend always just request it, because you can withdraw. And there's paperwork within your notice that you receive of the date and time of fair hearing that you can ask for the hearing to be moved, but also that you can ask for the hearing to be withdrawn. So as soon as you have more information, that's when you can at that point make a more informed decision. In the beginning, you might not feel like, once you're aware that you've been denied the second time, you might not have all the information you need to know whether to make a very good informed decision on whether you should continue the appeal or not. So our answer is always yes, continue your benefits while you can. Don't throw that option away for your beneficiary, or you as beneficiary, don't give your option away. Don't give up your right until you know for sure, once you received all the necessary information about the hearing, that maybe this wasn't a right decision, and at that time you can withdraw. But don't be someone who says, okay, I'm not going to do it loses continued services, and then decides, well, because I have 120 days, I guess let's do it, and just loses those couple of months of services and benefits, because you will. And that's kind of just never a good decision when it comes to someone receiving nursing therapy, things that are going to benefit your beneficiary, benefit yourself, that you're going to lose, that you can't necessarily always get back, because they're not going to give you the time back, or your therapist might not be able to make up the time. Your nurse might not be able to make up the time. So you just lost benefits unnecessarily. So let's not do that process. When it comes to the fair hearing, I think something that most people are a bit concerned about is as soon as you request your Medicaid fair hearing, you have to wait until you receive via mail an official fair hearing date notice from the Health and Human Services Commission Appeals Division. So you'll receive the documentation. It'll say who the fair hearing officer is. It'll provide you the date, time, the conference call-in number, the code that you have to call. The notice will include what you have the right to do. But just so that you're aware, you don't have to go through the process of the hearing alone, nor do you necessarily have to have legal counsel. So that means that if the beneficiary wants to have, so if it's a kiddo, if their parents could both participate, grandma can participate, aunt can participate. If it's an adult beneficiary, if they want their parents to participate, they can participate. If they want their attendant to participate, their attendant can participate. It's whoever they feel has the information about that service, about the individual. If they feel like they want them there, even if it's just for emotional support and they're not going to talk at all, they have the right to be there because the beneficiary has the right to bring individuals on their behalf. You also have the right, so when it talks about undue interference, you have the right to provide information. The beneficiary has the right. The representatives have the right to present information without undue interference. And what that means is that no one should interrupt, no one should ask you questions until you are done presenting. So although, there might be some issues, technically the rules, there's not rules of evidence that apply. So there's nothing that you necessarily have to know beforehand when presenting information. So there shouldn't be objections unless it's something that you want to talk about that's not necessarily relevant to the fair hearing. So the hearing officer might say, like, I understand you have issues with just how the Medicaid system is run, but we're here to talk about this specific service. So you have the floor, but you have the floor for a specific reason. So it has to be about the service that's being denied or appealed. It's okay to go off topic a little bit, but again, there's a time and place. So we've had some beneficiaries that wanted to talk about just how bad things have changed since things went to managed care. And although we definitely agree that there was changes and it's not as good of a situation, time and place. And so the undue interference comes with just being able to present information, present testimony, provide evidence without someone talking over you or tending to interrupt you or saying that this information can't be provided. The hearing officer will come into the rescue essentially if anyone is talking while you're talking. If there are any arguments, they will help resolve that. If there's questions that you have, they're going to allow you to ask those questions. But again, the argument itself that you have or the information you want to present, you have that right to do so with complete silence from the other parties. Just like they have that right as well to present their argument, you have that right as well. And you can, after the agency presents their information, so whether it be managed care, Health and Human Services Commission, Texas Medicaid Healthcare Partnership, whoever's presenting, you have the right to ask them questions. We call it cross-examination. If you're unrepresented, it doesn't have to necessarily be like a true cross. You might want to ask information just because you're confused. You have that right to ask them questions. We do have other videos on how to prepare specifically for a fair hearing. If you're interested and you want to attempt to do a hearing unassisted, at any point, even after you've gotten representation. If you feel more comfortable, we still advise you kind of go check that out and see, how you can go about getting a little bit better or more comfortable, I should say, with asking questions of the agency who made a decision. And then one of the things that we want to remind you is that if you submit information, we always recommend you submit it beforehand. But just because you didn't submit something prior to the hearing doesn't mean you're excluded from issuing additional information. So if you've had a recent appointment 2 days before the fair hearing, or if the beneficiary had something recently that was told to them or ordered for them, you can raise that at the fair hearing and let the hearing officer know, hearing officer so-and-so, I also want to mention, I received this order, I received this letter, I received this documentation, whatever it is, and would like to keep the hearing record open to submit that to you. The hearing officer is likely going to give you a date that which you have to submit that information. So if you have it, no problem. If it's something you're waiting for, you still have to advise the hearing officer that I was notified that, my doctor's wanting to submit something on my behalf. I'd like the record to be kept open. He or she will give you a due date. Try best to keep that due date, or if not, explain why. They might ask you to come back briefly so you can discuss that new documentation, or so the health plan can consider that documentation and then explain why that documentation is still not sufficient. So there's still an opportunity that even if you had the fair hearing, if there's something that was requested or mentioned, let's say, as a rationale that you're aware of, and someone is working on giving you that documentation, absolutely mention that, because you're not limited to providing information just before and during. If you can find it, if someone's working on it for you and you know it's coming, let them know to keep the record open. And then you can come back to another fair hearing date just to talk about that new documentation. There's a possibility the MCO could say, based on this information, we're going to approve the service, or they're going to provide more information as to why they feel like it's not sufficient. But you do have that right. What we want to mention, this is all before you physically proceed and call into Medicaid fair hearing. Obviously, you'd have within your fair hearing notice, you're going to have your prior denial notices included. But you should have already received your denial notices, both your initial and your secondary. You're going to receive your fair hearing notice, and then you'll receive your packet. Importance to the case file, you can request it. You might not need to request it. It's kind of depends on the individual, on the case, but also depends on, the most important thing is if you don't request it, just know that you have the right to it. You have the right to that information. You have the right to receive it before the fair hearing. And if you formally requested it and didn't receive it, you must notify the hearing officer. Normally, the policies that are utilized to make their decision are included within the fair hearing evidence packet. If they are not for any reason, that's something else you can bring up to the hearing officer. That they might have cited to it in their denial notices, but they didn't include that documentation within their evidence packet. You have the right to review that before fair hearing as well. So it's something to be aware of, because these are things to kind of highlight that if you do not have them in your packet prior to hearing, even if you have to proceed on the call, the date and time that is suggested, you call in and you tell the hearing officer before you begin or after they go through the introduction, I just want to let you know, hearing officer so-and-so, that I didn't receive, and it could be, I requested the case file on X date, never received it. I still haven't received the fair hearing evidence packet. I received the fair hearing evidence packet, but it's void of the policies they cited, and I need that information. Tell them everything that you are now aware of, that you have the right to, that you requested, or that you just have the right to in terms of the policy and regulations that you haven't received. And they have to deal with that as a pre-hearing process. So even though you're calling in and everyone thinks that you're proceeding to fair hearing, if you do not have this information, the hearing officer will note that order that it has to be provided by a specific date from the health plan, and then everyone gets their calendars out and you reschedule the hearing. Again, we want to just note that after you received or requested formally the fair hearing, you do have to receive additional documentation. Now, the actual letter that tells you the date and time comes from the Health and Human Services Commission Appeals Division. So you'll receive a packet from the Health and Human Services Commission, so HHSC. Each MCO is a bit different about how they handle their evidence packets, but you should still receive it. So some of them will send you, like the service coordinator will send you the FedEx receipt of this is when you should receive it. Others will just notify you like you're going to receive the evidence packet, and you might get it by regular mail. So it kind of just depends, but you absolutely should receive it before the fair hearing date. One of the biggest things that I think most individuals and beneficiaries don't realize is you can request a continuance. So if the date and time that's suggested, I think one of the biggest things that most hearing officers are aware of, and most beneficiaries tend to like think that, oh, I have to, please don't reschedule specialty like appointments and or even doctor's appointments, because we know that those sometimes can be hard to reschedule. And if you're seeing them every 3 months, every 6 months, or once a year, regardless, if you already have your appointment set and it's the date of your fair hearing, please request a continuance. Your healthcare needs come first. Please remember that. I feel like a lot of clients are like, well, we'll figure it out. Like, don't worry. We'll try and reschedule. If it's someone, especially that's hard to reschedule, and this is an appointment you've been waiting for because you haven't been feeling good, don't request. Don't just move forward with the hearing. Request that continuance. Hearing officers are very aware that life happens. And for those that are representing individuals or beneficiaries, if you're someone that's representing or advocating or even being there for the person that is the beneficiary, if you can't, for whatever reason, be there and they want you there to provide testimony, that's your reason to ask for a continuance. If you're waiting for a letter from a doctor and they say they're going to get it to you, you don't necessarily have to go through the process and then wait to ask for the record to be kept open, because they might give you a shorter window. Just ask for more time. If you ask for medical records, if you ask for the case file, you can mention all this information within your request for a continuance. So oftentimes what I tell my clients is you can get your fair hearing date and time, and it can be within 10 days to 15 days from the date of your letter. That's a very fast time to immediately go to fair hearing. If you know that your doctors want to participate, if you know that your nurse wants to participate, if you know that there's other people that want to participate, then you have to then prepare. 15 days isn't a lot of time. 10 days is not a lot of time. We don't proceed typically on the first fair hearing date because it's such a short window of time that we can't get in contact with all these individuals. We can't request records that fast. So it's okay to request a continuance, and it's okay sometimes to even request multiple continuances. Hearing officers are human. They understand that life happens. And I feel like the best thing to do is feel comfortable and confident that you're prepared to go to this fair hearing than feeling like things are rushed and that you can't proceed and that you're not feeling well, but you think you have to just go. You don't. So please remember that there's multiple reasons why you might need to request a continuance. Do not feel bad about needing to request a continuance. Their understanding, even if it's a day before, I've had clients who have ended up in the ER, just randomly, and we're feeling good one night. The beneficiary themselves calls me, or their parents call, and like, oh my goodness, we're scheduled for a hearing tomorrow, and we're gonna be in the hospital, and we don't know. It's okay. You can request a continuance, even if you're by yourself. You can still submit the information via email. You can worry about, if you have to call in later, but as long as there's some indication that you have requested continuance, you're better off. And someone can help you prove that you didn't just miss the fair hearing. But you have to request a continuance. Don't just not show up to your hearing and think that a continuance is going to be granted. Because if you do not show up to your hearing, if you don't call in, then they will close your appeal. You can reopen it. It's a bit of a different process. We wouldn't want you to have to do that. So just know that you have the right to request continuances, and it can be multiple continuances. Don't just think like, oh, I requested a continuance before and now I'm sick with COVID, or I lost my voice, or now I'm in the hospital. I can't request another continuance. Yes, you can. Normally there were in-person hearings. Now they're all done over the phone. You're not required to be anywhere. Your witnesses don't have to be in the same room as you. It's a little bit more convenient, but some instances we understand that, especially when it comes to like equipment, where they're saying this person can't navigate their equipment by themselves or they can't utilize it without assistance. If it's going to help to show this hearing officer in person that yes, I beneficiary can, or yes, that beneficiary can actually do what they're claiming they can't do, request an in-person hearing. It's still dependent on the hearing officers whether they're going to grant it. So even if there's not necessarily a circumstance where you think the person needs to be seen, you can still request an in-person hearing if you want, but it might not be granted. Just keep that in mind. So there's a reason why you think the person needs to be seen for a decision to be made. Request an in-person. If you just want to request it in person, you can, but if there's not necessarily a reason why they need to be seen, just know that the hearing officer might deny your request. Doesn't mean you're denied a request for a hearing. It just means the hearing is going to be over the phone, not in person. Also, as I mentioned, you can request the case file. Typically, you're automatically sent the fair hearing evidence packet. If for whatever reason you do not receive it, you can request it from the hearing officer as well and let them know ahead of time. You can also bring it up at the hearing that you didn't receive it, but it helps to receive it or to request it ahead of time if you haven't automatically received it. One of the bigger things to consider is that if you're a beneficiary or if you're representing a beneficiary that needs an interpreter or a translator, you have to make that request. You should try and make that request as soon as possible. So it's within the request for the actual Medicaid fair hearing, like your form will ask whether you need an interpreter or the beneficiary needs an interpreter. And the only reason why it's important is because you might call in and have requested or want to request an interpreter, and it's not always guaranteed that they're going to get it that day. So the hearing officers like to know ahead of time so they can make arrangements so that one, the interpreter is already or translator is already on the line when the beneficiary calls in, because it makes it a lot easier than trying to explain the language that the person or in a way the person doesn't understand, that they're having to put you on hold to request this individual. And then there's always a chance that they might not be able to get in contact with anyone, so they have to continue the hearing. So just FYI, you can request it beforehand. If you don't, for whatever reason, ask for it beforehand and it's still needed, ask for it at the fair hearing. Even if it means that you have to have the hearing continued, you have the right to it. So if you fail to check the box, if you forgot to check the box, it's not the end of the world. It's not the end of the request. You can always request at the fair hearing. Some of the basics. I think the biggest thing that tends to surprise beneficiaries, families, representatives, advocates is that when you hear informal, I don't think you really think that the hearing is as informal as it is. Or you think that wasn't technically that informal, like it followed a process. It does follow a process, but it is informal. And it's formal in the sense that you can be unrepresented within this process, and it should be explained to you beforehand by the hearing officer, like what to anticipate or expect or what to kind of follow. Like they'll mention, the agency was first, you have the right to ask them questions. We ask that you keep silent while the agency presents, and then you'll have the opportunity to present your case. So there is a formula, there is processes that they follow, and processes that they will let you know at the beginning of this is kind of what to expect, this is what to anticipate, but rules of evidence don't apply. So it is a way in which beneficiaries can navigate this process without needing advocacy, because they should be able to advocate on their own. But I think it's never really and truly how you anticipate it in terms of being informal. So it's like informally informal. But it is a process that it kind of takes time to get used to. So we're trying to go through the basics so that you know kind of what to expect. So you do call in, no one's going to call you. You have to call in, your witnesses have to call in to the phone number, add the code, and then state your name before you're officially entered into the process. And you will hear dial tones, like it'll say, welcome to, and this is the fraud and fair hearing system. And then after you're entered and you entered your code, it'll say like Avaya, And then it'll be another kind of break or pause before you're asked by this tone to enter your name, and then you'll officially be in the fair hearing process. One of the things also to consider is, I think most people presume that even though it's informal, when they hear hearing officer, they think it's someone that's an attorney or a judge or with a medical background, and that's not necessarily true. I think within the last year or two, they've had nurse hearing officers. That's not something they've had before. Typically, it was just someone who's been trained to be a hearing officer. So it's just your average Joe who applied and got accepted to be a hearing officer. They didn't have to have any legal background, they didn't have to have a medical background. So the presumption was always to explain things in a way that you would explain to family members who had no idea about your diagnosis, no idea about the beneficiary's diagnosis conditions, didn't know what that meant, because you couldn't guarantee that this hearing officer is aware of what these conditions are, especially the more the more rare the condition is, the likelihood that this person would know what it is or what it entails is extremely limited. Now with nurses, it's a bit better that they might know, but with some genetic conditions, you still do not presume that they know anything. So the presumption you're coming from is that this person, one, doesn't know the beneficiary, doesn't know you, doesn't know your kid. So you have to explain things when you're presenting in a way that they can understand, and understand what's exactly happening, because you can't presume that they know that just because I say I have this condition, they know that what it's going to entail for you or what it's going to entail for your loved one. They will mention that the rules of evidence do not apply. So if you do have attorneys involved, sometimes we do make objections. They're never really towards, it might be to certain questions. We might ask that certain evidence be excluded, but technically there's not legally a reason why the hearing officer has to do it. So if you submit something, if you say, my doctor told me this, there's no way to keep that information out. Pretty much anything that you want to submit to a fair hearing, anything you want to tell the hearing officer, so long as it pertains to the service that's being reduced or denied, or the waiver that's being reduced or denied, you're going to get that information in. That's what we mean by the rules of evidence do not apply. So it's unlike a court proceeding. I think one of the things that you might be presumed is there might be arguing. It's a really odd system, because again, they have the right to also not have undue interference with their testimony. So it's silence by all parties when one party is presenting information. And when it comes to questions that you might have, doesn't feel necessarily as adversarial, especially if you're asking questions that you just don't understand and you want them to provide information on. So that's something I think most people don't anticipate. And sometimes with the informality, you'll find that when they're presenting information, they're literally reading information from the evidence packet. So if you already don't know the rationale, if they're reading the denial notice again to you, that doesn't explain anything. I think that most beneficiaries and their loved ones anticipate that there should be some sort of sentence that says, I'm going to say, like, this particular reason is why they're denied. And if you don't get that, it's just really odd to you that we're at this process, at this procedure, and they're reading things from the evidence packet. One of the things to because their testimony can be very dry, very basic, I would say that one of the things to kind of consider is that when they're pointing to certain pages, you keep your evidence packet open and kind of look at what they're looking through or commenting on the documentation within their packet. I think that's more important than them reading their denial notice again, because you've already read it. You probably don't understand it because it's not specific to you. So that's not going to necessarily help things. One of the other considerations is that technically you don't have to provide testimony. You can ask the agency questions and you can say, I don't have any additional information to provide, because they bear the burden of proof. They have to prove you no longer need the service. They have to prove whether your conditions change. They have to prove why, even though you've had the service before, or even if it's a new service request, why it's not needed, why it's not necessary. although we find that it doesn't hurt to provide information, and we encourage most families to provide more information to give the hearing officer a better picture of what's going on. Because the other thing about it is there's still a human aspect of taking the beneficiary off of paper and actually explaining what's going on, because they only have what's going on with the beneficiary on paper. So they have you or your loved one, like, this is it, this is black and white. And you might have things, your loved one might have things going on that just need to be explained because no one's explained it, that this is what's actually happening in the home. And this is your opportunity to do that, to paint your picture, to show what's happening, to show that, hey, regardless of what they've told you thus far, whatever they've read from their little notes, this is what's actually happening. And this is why we feel like, or this is why we're concerned about losing the service. And this is what his doctors have told us. So that's your opportunity to provide more information. Even though you don't bear the burden of proof, it does not hurt for this hearing officer to hear that information from you. Even if you're unrepresented, sometimes their attorney does show up. And one thing that I want to point out too when it comes to the basics is when you call in, there might be multiple people on the line. The hearing officer always goes through a checklist of who's on the line and who they're there representing. Now, I will say when it comes to the managed care companies, they might bring multiple people, but typically only one person provides any testimony. So we always feel like they take care of this, or they do this action of bringing more people into the hearing as a form of intimidation. Just know, don't be intimidated. Only one person is going to do talking. And this person that is presenting, they've never physically assessed the beneficiary. They don't know the beneficiary. So that's another like positive about this process, that you're able to, and to consider, like, don't feel like you're intimidated because there's a medical director on the line. This medical director has never physically assessed a beneficiary. They don't know the person. They're also going based off of what's in writing versus what's happening. So it's okay if they have an attorney also present, because chances are they're not going to provide any information. And typically when it comes to attorneys, like, we cannot testify. So they can't testify on your behalf. We can't testify on your behalf. We can help our clients present their arguments, but we cannot physically testify. So if their attorney is present, they're just going to ask potentially their testifier, or the person that's testifying on the agency's behalf, questions to help their case, but they can't physically provide a whole lot of information. So it's not something to also be intimidated by. And again, it's another person that has no idea about the beneficiary who's participating in this process. I will want to encourage that, before I get started with this slide, that the beneficiaries, or the representatives of the beneficiaries, you have the most information about your own health or about your beneficiary's health. You are the most dangerous person to ask any questions about, or any questions to, because they cannot anticipate what your answer is going to be. And out of everyone in the fair hearing room, you have the most information. You know them, that you know yourself more than anyone else is going to ever know. So utilize that to your advantage. Don't be intimidated by people who do not know you, who do not know your condition, who do not know the ins and outs of what's going on in your day-to-day. You know yourself better, or this individual knows themselves better than anyone else will. So just keep that in mind. The hearing officer always does start with introductions. As I mentioned, you got to make sure that everyone is aware of who else is on the call. If you're unrepresented, they might ask, and even if you are represented, they might ask if they have to go over the fair hearing process. Sometimes attorneys will say, no, you don't. I've already gone through that with my client. It doesn't hurt to know, and they'll tell you like the typical process. This is what they ask of you. I ask that you remain silent, that you put your phone on mute while the other person's talking. You will have the opportunity. So they can go over the process, and then let you know like what their role is. Like, I'm so-and-so hearing officer. My job here today is to make sure that the decision is made on this case, and they'll explain what your situation is, what the denial is, if that's your understanding. They'll make sure that everything that has been sent to you, or that you sent in to them, has been admitted into the record. And then they'll make sure that everyone that's providing testimony or is there to provide testimony is sworn in. And then that's when the process fully starts to take place. Now, this hearing officer that's kind of doing this interview, doing the overview, you might find that they don't ask a whole lot of questions. They might just be listening and taking notes. They don't necessarily have to take an active role in this process besides making sure, like, okay, agency says they're done. Do you have any questions for the agency? If not, go ahead and proceed with your argument. So they do have oversight, but certain hearing officers get more involved, others don't. They just do their job, listen to both sides, let everyone know when they have to issue their decision. More often than not, something just as a caveat that we find, it's at the introduction of evidence phase that normally, if there's going to be a problem because they've submitted something or you've submitted something that they haven't reviewed, that could cause a continuance. So at this stage, if they're saying like, we submitted 2 packets and you've only received 1, you need to say, and they will ask you, okay, I've received a 38-page packet and an 88-page packet. These are the days I received them. Did you receive both packets? And you just have to answer truthfully and say, I received the 88 packet. I did not receive this additional second packet. They can send it to you. Do not be afraid if they say like, oh, we can email it to you now. Like, do you want 10 minutes to review the information? And you don't have to say like, yeah, that's going to work. You can say like, I need time to review this. I need time to talk to this, especially if it's just you as a beneficiary. Say, I need time to review it and see if I can talk to anyone about the information. Do not commit to reviewing it then and there and making a decision to proceed to fair hearing because you do not have to. Again, you had the right to review the information and prepare prior to fair hearing. If you don't have that opportunity to prepare, let the hearing officer know. They should know better than to expect you to proceed, but some individuals want to. I never choose to proceed until I talk to my client about the additional documentation, even if it's a couple pages, because I can't talk to them privately oftentimes or with enough time before they expect me to make a decision. And you want that opportunity. As I mentioned, the decision has to be in writing. Although they give a due date, do not be concerned if they bypass that due date. If you have continuation of services, they might push your due date and prioritize cases where the individual does not have continued services or cases where they need to make a quicker decision. Because the hearing is recorded, they can go back and review their notes and re-listen to the hearing before they actually put their decision in writing. So it's okay. It doesn't mean that you're going to lose or you're going to win. They take more time might be necessary. And then again, when it comes to the authorizations, most MCOs do put the due date, like the end date of an authorization, the date of your fair hearing. That's incorrect because you will receive continued services until the fair hearing decision is issued to you. One thing to note is that if you are successful at fair hearing, but your authorization period has expired, which, as I mentioned, sometimes you're in a fair hearing for an authorization that's lasts 3 months. You might be in a hearing that the authorization lasts 6 months, but the hearing decision took so long that we're arguing about an authorization period that has expired. So if you're successful or if you lose, that agency that has requested the service still has to issue their new authorization. So win or lose, they have to resubmit. Now, if you lose and they're saying, well, we're going to request what they previously approved, you can argue with your agency to request what the doctor signs off on and what you continue to need. Fortunately, you can go through a fair hearing, you can be successful, and the MCO can try and deny your next authorization cycle. It's never a guarantee that because you won during the previous authorization cycle that they're not going to make you go through it again. Although chances are, if it's a very short window, that they might consider not going through it because the hearing officer is not going to be entirely happy, because you can request the same hearing officer if you just went through this process, just won, and they're trying to deny you again. The other, I guess, good thing potentially about it is, if you think about it, as I mentioned, so sometimes your agency, your therapy agency, your nursing agency, they'll submit when there's changes in your condition during the appeals process. Now, the MCO might not consider that information because you're under a continuation of service authorization. So if your agency doesn't notify them that, hey, this has changed, chances are they received your new authorization. They know that, okay, the authorization is set to expire, but we're in for a hearing, so we don't consider this. So if you lose, one thing to consider is if you had a change of condition, chances are your health plan didn't consider that change. So now that a decision has been formulated, they will consider your new next authorization cycle. So we've seen where clients have lost at their fair hearing, but they maintain their hours because they were approved at their next authorization cycle. Or we've seen where the agency participated or someone participated on the beneficiary's behalf. They heard everything that was said at their hearing, and they just corrected their authorization. So when the service is approved or denied, they resubmit, and there's a chance for the authorization to be approved without having to go through another appeal. So that's why we talk about this last little bullet about the resubmission should set out current conditions and or nursing needs, because it might not be as up to date with what we were dealing with in our prior decision within the prior authorization cycle. So there's a chance that you might not have to go through appeal because things were changed, but because the managed care organization refused to consider those changes while you were in appeal. Again, the timeline for the date is typically 90 days from the date the appeal request was received. As I mentioned, that can be extended. It's not a problem. I think the hearing officer's gotten a bit better about their timelines. I know before they weren't, and we were waiting like months and months, which honestly, if the service is being continued, it's okay. You know, we're okay with that. It would be, of course, beneficial to get a decision, but it wasn't necessarily a detriment to say like, hey, take your time. It's been 4 or 5 months, but services are being continued, so you know, keep the course. But normally, I think they're getting better. They're trying to stick within their timelines, and if they do tend to go over, they'll try to notify the parties that they're issuing a decision soon. One of the things that we want to talk about, and a lot of clients, a lot of beneficiaries have questions about, is there is language within both the initial and final denial notices before you request a fair hearing about recoupment of funds. So if you request an appeal and you're unsuccessful, that they might try and seek funds for the cost of services. This has been in writing for years and is always included within denial notices. We can say as an agency that we've never seen it be enforced. And the reason why is that we've never seen an MCO ask the Health and Human Services Commission for permission to seek recoupment. And that's something that they would have to do. They would have to seek recoupment permission from the Health and Human Services Commission to extract funds for the services from the beneficiary. We see this as an intimidation factor only, because again, we haven't ever seen it enforced, that they will include this to try and deter people or try to prevent people from requesting an appeal with continuation of services. Obviously, a lot of parents and a lot of beneficiaries are concerned with the higher costing services like nursing, which they know that they couldn't afford to provide all the continuous services that they're able to receive during this months-long process. So I wouldn't be too concerned about the language. Again, we've never seen it done. And I don't think typically they would anticipate that they could receive any of the funds back from Medicaid beneficiaries for the full extent of the services. So even after you get a fair hearing decision, obviously if it's unfavorable, you're probably wondering, well, what can I do at this point? Depending on the type of service, kind of depends on what you might consider doing. Obviously, if it's a 3-month authorization or 6-month authorization, it's a recurring service. The easiest thing might be to resubmit. Although you have the appeal, you have a right to appeal further and request a judicial review, which is the final bullet with the district court in Travis County. That's taking it next level of actual litigation before a court. Services do not continue though. So if you're dealing with 3-month to 6-month authorizations where you're going to be up to be reassessed, that's why we think it's best to resubmit versus going without the service through judicial review, because judicial review is going to take quite some time before you're able to actually present in court, and that entire time you don't get services continued when you ask for a judicial review. And that typically also occurs even after you request an administrative review. So before you get to judicial review, you do ask for an administrative review. While you ask for administrative review, that too, you do not get continued services. So it just depends. For a lot of people, you might consider requesting administrative review to see, what the outcome is going to be, but you have to resubmit in the interim because you won't have the service continued. And oftentimes we advise you do both. You do have a time frame to request an administrative review and receive a formal decision. So what happens to a lot of beneficiaries that if they have a short authorization cycle or period, they might do both, be unsuccessful in administrative review, or not even complete administrative review process because they let them know, my agency resubmitted, we got approved, we no longer need it. That's something you would have to do though. If you request an administrative review, even if you do so on your own, let them know if you also resubmit and you're approved, because then they don't have to make a decision. Please don't allow them to do a decision that's detrimental to your case. So resubmission is probably the easiest. If it's something that you can't resubmit, you have to do administrative review, do that process. Something else to consider is if you have new information, you can request that the hearing be reopened. So if you receive documentation that you think would have affected the outcome of the hearing, something that they might have mentioned. So sometimes the MCOs, when you ask them questions, do say like, yeah, maybe if we had this, or they might let slip what they were looking for. If you have that, you can absolutely request the hearing to be reopened and provide that information. I believe you have 6 months to request the hearing to be reopened. Obviously, we don't want to waste that much time because, again, as soon as you get the fair hearing decision, the decision is implemented within a certain time frame, and you'll receive notice from the managed care company of when that time frame actually goes into effect. That is an option still, but technically, I think in the hierarchy of things, probably resubmission is your quickest bet to get a new decision. But you still have to be aware of that you have these rights to take these actions after a loss at fair hearing. When we talk about amended or reissued decisions, it could be so you'll receive a decision in writing. It often isn't what you anticipate. I'll just say that. So you have to look at your fair hearing decision. It often it'll have findings of facts and conclusions of law. The findings of facts are often things that weren't ever in contention or argument. Like it'll have your diagnosis. Like no one's arguing what your diagnoses are. Those are just facts. But you would hope that the findings of facts would be something that was argued at hearing. A hearing officer say, well, this is the actual fact because they presented this. That doesn't tend to happen. So you really focus on the conclusions of law. If there's something that's incorrect within the findings of facts or conclusion of law, you can absolutely point that out to the hearing officer, and it could cause them to amend or revise their decision. And that means that they would resubmit a decision to all the parties, and then you can make your decision from there. So there's an opportunity for you to say, like, you said this was a fact, this is wrong, or this conclusion of law that you provided as rationale to support the decision is also wrong. It doesn't happen that often that you would get that level of error that could cause it to be completely like overturned, but it's a possibility, so something that you have to be aware of. And that concludes our presentations on appeals and fair hearing process. We do hope, and this was supported by these organizations, that we're creating these informational videos to help you advocate for yourself and to better understand the process so that if you needed to, you could advocate on your own behalf or advocate on behalf of someone that you love. So we hope this information was helpful. You can always seek further assistance from these organizations as well as Disability Rights Texas.
For assistance with Medicaid appeals, call our intake line at 1-800-252-9108 or visit www.drtx.org/Medicaid appeals to find our related self-advocacy resources.